Hello, welcome to Missouri Department of Health's next Wellness Watch. We are excited to have Jason Simmons with us today. Jason is a member in the law firm of Cripps and Simmons, LLC. He graduated from Washburn University School of Law in 2001 with his law degree, and later that same year completed his LLM in taxation from the University of Missouri, Kansas City School of Law. Jason moved to the Columbia area in early 2003 and provides legal services in the areas of business and tax planning, estate and trust administration, real estate transactions, tax controversy matters, and fiduciary litigation. Jason believes that it is extremely important to develop a good relationship with his clients based on both education and open communication so that the client's goals can be obtained. When not working, Jason enjoys spending time with his wife, Pat, and 2 sons, as well as hunting and fishing with his family and friends. Thank you, Jason, for being here, and he's going to talk today about basic estate planning.
Thank you, Carla. Again, my topic today is basic estate planning, how to set up a last will and testament, and basic powers of attorney. We'll get right into it. Basic estate planning is trying to cover 2 different types of situations. Situations of incapacity or disability, when you are unable to make your own financial or healthcare decisions while you're living. And then the second one is what happens to property at your death. And kind of a threshold question we need to talk about is what is probate and why does everyone want to avoid it? Probate is simply it's a court process. There are 2 different types of probate. There's lifetime probate. These involve guardianship matters, which involves the care and custody of another person, and then conservatorship matters, and these involves the management of finances of another person. And then there's post-death probate, and this is more commonly known as decedent's estates for those types of attorneys that practice in this area. And one of the questions that always get asked is what happens if I don't do any planning? Basically, again, what we're going to do is we're going to be subject to guardianship and conservatorship while you're living. A person that needs a guardianship or conservatorship has to have somebody go to court to get legal authority to make the financial decisions, have access to bank and financial accounts, to have access to healthcare records and information, and to make healthcare decisions. It can be costly, time-consuming, and requires significant reporting and record keeping. And this can all be avoided. When you don't do any planning and you pass away, then we have a decedent's estate, and it's known as intestate succession. In this type of a situation, if we have a full administration, then we have to make application for letters of administration. The property that you own that's subject to probate is going to transfer by intestate succession, and then it may require additional effort, cost, or consents from your heirs depending upon the type of probate procedure that's required. And there are different types. Some are full administration. There are some simplified procedures, such as a spousal refusal, a small estate affidavit, or a creditor's refusal of letters. So to avoid guardianships and conservatorships, there's a couple things that you can do. Again, when planning for incapacity, you want to make sure that somebody has access to financial resources, has access to healthcare information, that they have the capacity to make healthcare decisions, and that they also have the ability to pay for long-term care. A general durable power of attorney is one of the first documents that we recommend clients have. A couple of definitions that's helpful to have. The principal is the person giving the power or signing the power of attorney. The attorney, in fact, or the agent, is the person that's with the power to act on behalf of the principal. The authority does die with the principal. There are a couple of minor exceptions, namely, who has the ability to designate how burial arrangements are going to be made, whether or not there's a traditional funeral, or whether or not there's going to be cremation, and the types of services that are going to be provided. It can be effective when it's signed, or what's known as a springing power of attorney. Typically, the springing means that a physician has to certify that the individual is not capable of making decisions that are at issue, whether it be financial or whether it be healthcare. A durable power of attorney is important because if it's not durable, then it's not effective during periods of incapacity. And under the Missouri statutes, there is a requirement that certain language be included. To some language that's required to be included in the power of attorney. If you want to make or amend a trust, that language has to be explicitly stated. If you want to give the attorney, in fact, the authority to make gifts or to change beneficiary designations, then that authority must also be specifically granted under the terms of the power of attorney. Under healthcare powers of attorney, this document here is going to cover a couple of different things. Typically, it's going to cover a living will or a healthcare declaration. That's going to be end-of-life decisions. And then it's also going to grant the authority to have access to the protected health information covered by HIPAA and to make medical decisions for you. Again, it is referred to as a living will, healthcare directive, or healthcare declaration. These types of documents are always springy. And if you think about it, that makes a little bit of sense because if you can make your own healthcare decisions, nobody else should be making them for you. In Missouri, you must specifically authorize the withholding or the withdrawal of food or water if you want to grant that power to your attorney in fact. You can include what's known as the right of sepulcher. Again, this is just the ability to designate funeral arrangements in the final resting place. I find it important to include these powers in a healthcare power of attorney because your will is not effective unless and until it is admitted to probate. And that generally can't happen right after your death because you need to have death certificates, you need to meet with the attorney, and you need to make application to the probate court, and then the probate court has to, in fact, act upon that. So we like to include the right of sepulcher in our healthcare powers of attorney, and this is one of the few powers that will extend beyond death. And again, these types of documents do vary from state to state. So if you're moving around, you want to make sure that if you move from Missouri to another state, that you have a document that is effective in the other state. The second topic is going to be the post-death probate administration. Again, this is going to be the decedent's estates. When we're planning for death, we have a couple of different things, main documents or tools in the basket, if you will, to deal with planning for death. So we have what we would call a simple last will and testament. We would have a last will and testament, or last will and testament with testamentary trust provisions. That's a typo there. And then other options do exist, but they're really beyond the scope of this presentation based on the title. And these are going to be your revocable trust, the way that you own property ownership and beneficiary designations and things like that. Wills generally only control the probate estate. And the probate estate consists of property that somebody owns in their individual name that does not otherwise transfer by operation of law. So by way of example, if you own property jointly with your spouse, then upon your death, it's not going to be subject to probate. Instead, it would all pass to the surviving spouse. In contrast, when your spouse passes away, unless they've utilized some sort of a non-probate transfer, then their will would control the disposition of that property. Wills do not avoid probate. Again, in fact, for the will to be valid, it has to be admitted to probate, and then it only controls the property that is subject to probate. They do not trump joint ownership or beneficiary designations. So if you've named somebody as a beneficiary on a life insurance policy, on a bank account, or vehicle, something along those lines, then that will is not going to trump that beneficiary designation. Similarly, if you own property jointly with another person with rights of survivorship, then that is not going to trump that form of ownership either. And upon your death, then the entirety of that property is going to pass to the surviving joint owner. Having a will is the only way to nominate a guardian for minor children. So if you have minor children and you want to designate who's going to be the guardian, who they're going to live with, who's going to make their medical and placement decisions while they remain a minor under the age of 18 in Missouri, then the way that you do that is you nominate them in your last will and testament. That will has to be admitted to probate, and that needs to happen within 1 year from the date of your death in Missouri. If that will is not offered to probate within 1 year, then it's as if that will had never been signed and never existed. the person that is named or nominated as the guardian still has to take the steps of applying to be appointed as the legal guardian for that minor child. And that's kind of how we had generally talked about before with application for guardianship and conservatorship. And in Missouri, you can give away items of tangible personal property by a written list, which supplements the will. Typically, you do need to reference the statute in Missouri that allows you to do this. And then after that's done, you can make that written list and you can describe that property and where it's supposed to go. We'll talk a little bit about this in a slide or two below. A simple last will and testament is going to designate who is going to administer the estate. In Missouri, this person is what's known as the personal representative. You can have a single personal representative or you can have co-personal representatives. The will is going to designate who is going to receive your property, typically your beneficiaries or beneficiaries, if you will. Should provide for both a primary set of beneficiaries and contingent beneficiaries in case the primary beneficiary does not survive. So a lot of the simple wills that I'll prepare will state that if they own any property at their death, the property goes to the surviving spouse. If the spouse doesn't survive, then everything goes to the kids. Again, the simple last will and testament should nominate a guardian for any minor children that you have or may have. I will typically name a first person, and then I like to have a first alternate and maybe a second alternate. That's the same with the personal representatives as well. And in will in Missouri, you can authorize independent administration, and you can waive the requirement to post a surety bond. And basically what this does is it allows the personal representative to simply do what it is that they need to do to administer the estate. They can reduce any real property, personal property to cash. They can sell items or they can keep those items if they're going to be distributed. But again, they can do so without court authorization or direct court supervision on anything that they would try to do. The personal representative does always have the authority to ask the court for instructions, even in an independent administration. The contrast to that is that the estate would be supervised. If the estate's supervised, then the personal representative typically has to obtain permission from the court to do anything. So if they're going to keep a piece of real estate and they need to pay the taxes or the utilities or rent it out, then they would have to get an order to take charge of the real estate. They would pay the insurance in that circumstance. If they wanted to sell it, they would have to file a motion to sell the property. Once they received the contract on it, then they would have to file what's known as a report of sale, and then get an order confirming the sale once that's been on file. And there are procedures and timelines and things that have to be followed to make sure that that happens. Similarly, if there's any personal property that needs to be sold, an order would have to be obtained to permit the sale of that property. And if there's a business that needs to be maintained, then we have to file an order to continue the business and instructions from the court on that. It's just more, a lot more effort, a lot more work, and it can delay the timing of the administration of the estate, basically make it take a little bit longer. Testamentary trust, this is a different type of a trust, but this would be a trust that is created. So you have all of the same information that we've talked about with simple wills, but you also have a couple of other things. Again, it's going to be a trust that's created in a will. It does not exist until death, and it's only created if it's needed. So if you leave everything to a surviving spouse, and then the remainder is to be divided among your children, if those children are under age 25, then, and if you pass away while they're under that age, then the trust would be created. If they are all over the age of 25 at your death, then it would just be an outright distribution. These are commonly used with young families, and it's to give direction and instruction as to who's to manage the assets for the children and upon what terms and conditions. Some examples of this would be to pay for college, and then they would get all or a portion of their share with final distribution to need to be made at a future date. You can also come up with stepped distribution. So maybe they get a third at age 25, half of the remainder at 30, and the balance at age 35. These are generally not very well known in the financial world. Sometimes you'll have to work with financial advisors and the life insurance companies to get them to designate a testamentary trust. They can create adverse tax consequences when you're dealing with qualified plan funds. And again, that's kind of something that needs to be addressed on a case-by-case basis and would be beyond the scope of a general presentation. But they do have a purpose. Generally, this is done with younger families. They have a personal residence. Oftentimes, that personal residence will have a mortgage against it that's a fairly sizable amount with not a lot of equity. And the main asset that they're worried about being able to be managed for their children is going to be life insurance. So they're not going to have a lot of the asset management features that a revocable trust might have. But again, sometimes these are a great way to implement a plan when a trust would be appropriate. Heirlooms and personal items, again, this is kind of the written list that we've talked about. It must be referenced in the will or a trust if you have a revocable trust. This written list can be changed or added to from time to time. The person does need to adequately describe the item. So if you have multiple diamond earrings, then you may need to describe the size of the diamond, whether or not it's encased in a platinum or gold or silver, something along those lines. It does need to be signed and dated. It can be typed out, but then it just needs to be signed and dated. And this is generally going to be more effective than masking tape. So oftentimes I hear stories about, well, mom put a piece of tape on the back of the hutch and it was supposed to be mine, but when we went there, the piece of tape, it fell off. Some would question whether or not it fell off. Some would question whether or not it had help. And then this written list, along with all of your estate planning documents, should be kept in a safe place. So some common misconceptions and myths about wills is that wills avoid probate. And we talked about that briefly and said that they do not. The power of attorney will allow access to my accounts after my death. Again, that is a fallacy. It simply does not. If you go to the bank with the power of attorney and say, mom passed away, unless you are an owner, they're going to go ahead and lock that account. My will says who gets my assets. Again, this isn't necessarily true in that if it's titled jointly or if there's a beneficiary designation on an asset, then that's going to control who gets your property. Everyone needs a trust. While trusts are a great way to provide for asset management while you're alive and for purposes of avoiding probate and dealing with contingencies, mainly such as if somebody passes away before you, not everyone needs a trust, and there are other ways to accomplish transferring property upon death and avoiding probate without a trust. Again, some of the other common misconceptions and myths is that my spouse will get it all. In Missouri, intestate succession says that if you are married and you both have children with the other and no other children with any other person, that the spouse is going to be entitled to receive the first $20,000 of property and then one half the balance, and the children will receive the other one half. So common scenario is that husband and wife have two children. The wife would be entitled to the first $20,000 and half the balance, and then each of the two kids would share a quarter apiece. The lawyers, court, and state will get it all. While there are fees and there are costs associated with the transfer of property that is subject to probate, typically it's not going to consume an entire estate. It would have to be a fairly small estate for that to happen, and there would have to be some pretty extenuating circumstances to drive the cost up to make that happen. And then another common misconception and myth is if I become incapacitated, my spouse can take care of all of my affairs. And that's just unfortunately not true. There's no statute that allows somebody to make financial decisions or even medical decisions for a person that's incapacitated and unable to manage their own affairs. We did have some questions that we received in advance. First question is how to name young children as beneficiary for benefits. And this really depends upon the nature of the assets being transferred and whether the estate plans includes either a testamentary or revocable trust. If no trust is involved, then setting up a custodial transfer may be best, such as the following. And I've got an example in the presentation materials. To George Q. Jones as custodian for Billy D. Smith, as custodian under the Missouri Uniform Transfer to Minors Act. This is going to be a situation in which George is going to be the trusted adult and Billy's going to be the minor. In this type of a custodial transfer, George will have the authority to manage this account until Billy turns 21. When Billy turns 21, at that time, he would be able to get access to those funds and be able to use them for whatever purpose he deems appropriate at that time. Another question: what are options to handle a property that has been paid off and keep it out of probate? So again, as I alluded to a couple times before, avoiding probate, whether a property is paid off or not, can be accomplished through joint ownership or designation of a beneficiary upon death. In Missouri, and for real estate, this is accomplished with a beneficiary deed. Both Missouri and about 26 other states have a beneficiary deed or some other document that will transfer ownership of real estate if you own it upon your death. There are certain requirements in Missouri for that beneficiary deed to be effective. Namely, it does have to be recorded prior to the individual's death. For financial accounts, such as your bank accounts, money market accounts, brokerage accounts, life insurance or retirement accounts, you can avoid probate through the use of designating beneficiaries. Again, generally speaking, we're going to have a primary beneficiary and then a group of contingent beneficiaries. Note that most bank accounts, such as a savings account or a checking account, you can only name one line of beneficiaries, so a primary beneficiary only. For vehicles that are titled to the Missouri Department of Revenue, you can avoid probate on these types of assets by having a TOD beneficiary, which is an acronym for a transfer on death beneficiary. That's done at the title, done on the title at the license office, and the cost to have a new title issued is $14.50 currently. This will have to be done in person, and you do have to take your existing title to the Department of Motor Vehicles to make that happen. For tangible personal property, you can use the beneficiary designation. This is going to be something a little bit different than the written list. Chapter 461 of the Missouri statutes allow for beneficiary designations, and we routinely use these to avoid probate with respect to the items of personal property. This is going to be items such as furniture, household goods, shop tools, things of that nature. One kind of caveat here: if you do have a safety deposit box, there's no option for designating the beneficiary on those. The only way that you can transfer ownership upon death is by naming somebody as a joint owner on that safety deposit box. Next question: are there generic forms for a last will and testament and/or powers of attorney? Kind of three answers on this one. The preparation of the last will and testament is required to meet specific requirements to be valid, both in content and to take advantage of different options and the manner of signing. So typically for a will to be self-proving, it has to contain specific language. It has to be witnessed by two disinterested individuals, and then both the witnesses and the person signing the will have to have their signatures notarized. And while there are forms that are available online, I do not recommend using them. I had a friend recently came in after her husband had passed away. They had gotten a will online. It had been completed, and they had indicated that some of the property was to go to the spouse, the surviving spouse, but the residue, basically everything else, they didn't name a beneficiary on. And so luckily we had a situation where there wasn't any other property. Again, in that circumstance, the real property, which would have fell as part of the residue, was jointly owned between the two spouses. But that was a situation in which there could have been a problem. Financial powers of attorney, those can be obtained online. You can also get them in the stationery section of an office supply store or even some other big box stores. Again, I generally do not recommend using them, as they can be state specific and must be completed properly. Early on in my career, I met with a young son. His father had dementia, was not able to make decisions anymore. He came in with a power of attorney and was upset that the bank wouldn't allow him to make any decisions for his father, and he didn't understand why. And when we looked at it, we found out that, or at least I found out pretty quickly, that the dad needed to initial all of the powers that were granted, and because dad didn't initial any of the powers and simply signed the form while it was validly signed, he didn't grant any authority to the son. And so the net effect of that is that they had to go through and pursue a conservatorship so that the son was able to manage the assets for dad. And then healthcare powers of attorney, these can be obtained online in several places. And Missouri Bar does offer a free booklet. I have one here. On the additional resources page, I have a link to this, but this here is the form. And this contains 3 different parts. It does have the healthcare directive, which is end of life decisions. It does have the power of attorney for healthcare decisions, basically allowing somebody else to make those decisions for you. And then it also has what's known as a HIPAA privacy authorization form. And this form will authorize the release of a client's or an individual's protected health information, regardless of whether or not the individual is incapacitated or not. So this basically just allows information sharing. Question: are state-specific online forms adequate for uncomplicated estate planning, such as a will, durable power of attorney, and living wills? For example, assets under $1 million and no minor children. Again, this is, as I had alluded to before, there's nothing inherently wrong with online forms, but filling them out and making sure that they are signed in the proper manner are extremely important. For the reasons I explained before, I generally do not recommend this method, as any errors are oftentimes not discovered until it's too late to correct them. Remember that when you're hiring an attorney to help with your estate planning, you're not just getting a form, but you're also getting their expertise to make sure that your wishes are properly set forth in your documents. Oftentimes we'll discuss things and we'll find out that the family members don't necessarily get along, and so sometimes that'll lead to a different recommendation as to what planning should be put in place and how to do that. And that's something that we as attorneys are going to be able to have that conversation with you about. Additionally, sometimes the online forms can cost more than what a local attorney would charge to prepare your plan. Oftentimes I have found and heard from clients that have gone to some of the larger online companies for either business planning or estate planning to prepare their documents. They'll come in later, they'll ask me to review them, and when they tell me what they paid for that product or service, I find out that one, it doesn't meet what the wishes are, and then two, they've paid more than what I would have charged them to prepare it right the first time. Oftentimes they'll go ahead and hire me to prepare their documents at that point correctly so that their wishes are met. Question: please give recommendations for marriage late in life and planning for assets regarding adult children on each side and allocations for the living spouse in case of death. This question here deals with the blended family. It's going to vary from case to case, and the parties to the marriage should obtain competent legal advice from one or more attorneys. Sometimes it's very common that we'll represent spouses in a second marriage in which there are children from a prior relationship. Sometimes they have his, hers, and ours. And we just need to have a frank conversation with them about what the best way to accomplish their goals are. Sometimes consideration should be given as to whether or not the parties should enter into either a prenuptial agreement or a postnuptial agreement. A prenuptial agreement is going to be entered into before they get married, and it's going to define division of property and ownership rights and things of that nature, whereas a postnuptial agreement explain what happens after you've been married. Postnuptial agreements are somewhat special in that you've got to make sure that they're supported by adequate consideration. Otherwise, you have a situation in which it may not be binding at the time that it becomes necessary. Next question. If an heir named in my will predeceases me and I have not updated my will, who is next in line to receive my assets? For this question here, it honestly depends on what language is included in the will and whether the heir, the person that you have named, is a blood relative or a spouse. If they're a blood relative or a spouse and the will is silent on whether or not the bequest or devise is per stirpes or per capita, then the deceased heir's share will go to their descendants. Basically, if you're leaving property to a blood relative, if they do not survive you, then their share is going to be split among their children, grandchildren, and so forth. If they're not a blood relative and the will is silent on the issue, so it doesn't say that the distribution is per stirpes or per capita, then that gift is going to lapse and no one's going to get that distribution. Instead, it would be distributed as part of a residuary. Occasionally, this will happen where there is no residuary, or the person that is named as receiving the property doesn't survive and is not a family member, and there's not a contingent beneficiary named after that person. In that circumstance, then what we're going to have is that residue would be distributed according to intestate succession. If the document does state that the distributions are per stirpes or per capita, then the language in the will is going to control. Explanation of per stirpes and per capita. Per stirpes means that if your beneficiary deceases you or dies before you, then their share is going to go to their descendants. A per capita is going to be that if you've named multiple beneficiaries at that level, then the person who predeceased is going to be split amongst all those others in the same level. So by way of example, individual has a total of 5 children. 3 have survived, 2 have predeceased. One of the predeceased children has 2 children. In that type of a circumstance, if it's a per stirpes, then it's going to be split into quarters, with the deceased child's share being split among his 2 children. And if it were per capita, then it would only be divided in 3 ways among the 3 surviving, and the 2 grandchildren would get nothing. A couple of additional resources. The Missouri Bar does have a probate law resource guide. This document right here is something that I provide to clients in my office. It'll kind of review a lot of the things that we've talked about. It's going to talk about probate in general. It's going to talk about wills, revocable living trust, joint tenancy, which is form of property ownership. It's going to talk about living wills and other advanced directives, the durable power of attorney, and comical gifts, and then guardians and conservators under Missouri law. If you click on the link in the presentation, that'll take you to the online version of that. And then there is the Missouri Bar Durable Power of Attorney for Healthcare and Healthcare Directive, and then the HIPAA Privacy Authorization Form. Again, that is going to be this document here. It does have instructions on how to complete this document, some special notes, and things like that. And again, this is going to be freely available on the Missouri Bar's website. Thank you for the opportunity to give this presentation. I appreciate the ability to do so. And Carla, with that, I'll turn it back over to you.
Thanks, Jason, for a great presentation. I want to remind everybody to click the link at the bottom of the video for a chance to win a prize. And thank you for watching the financial dimension of the Wellness Watch series.